tell you no more movies, no more going out to dinner, no more fun. They're going to just focus on bills and necessities because you need to be reorganizing your life. Okay, kind of like that. All right, so that's objections to the plan. Remember, usually the unsecured creditors like to object. They usually just get kind of looked over, though, honestly. They're more worried about the secure creditors. So modification of the plan, remember what he said? He said, you might get into a chapter 13, right? Everything looks good. You are, your disposable income is $32.50 a month. Good. You're paying everything on time for the first, I don't know, 5 months. Everything looks good. Then all of a sudden you come to a bump in the road, right? Everybody sometimes comes to a bump in the road. What I mean by the bump in the road is something unexpected happens to you where it's like, I'm not sure if I'm going to be able to make that 6 payment. Okay. You're just unsure. Okay. First option is this, and you have to remind clients of this because clients like to procrastinate. So if they know there's a bump in the road, it's right there, right? There's a bump in the road and they ignore it. Most people ignore it. And they come to you back to the attorney's office one day before the 6th payment's due. And then they tell you about this bump in the road. So you always want to remind clients, if you think that's something, it may be possible that you're not going to be able to make the next month's payment and and as soon as you know that or assume that or think that, or you hit the bump in the road, you need to give us a call because we need some time to clear this up. We cannot just say to the courts, let's just say the 6th payment was due 5 days ago. And now your client comes into your office and says, I can't make that 6th payment. 5 days are already into being late. The court's not going to work with you then. Okay. But if you stay it here and you assume it, and it might happen, and they tell you about it, the bump in the road, that's what you need to know. And if you know that, like it said in the video, you can modify the plan. Okay, so there is modification. They can maybe, if it all works out, they can maybe reduce this. Let's just say you're having a little bump in the road, right? And you can only afford, I don't know, $2,900 a month now for whatever reasons. Okay. They might be able to adjust this and the creditors might be okay with it. And then we can keep on moving forward. Okay. But if the bump in the road is so bad where your client has lost their job, there's no more income, whatever the situation is, okay, they have zero. They're thinking they're going to have $0 to continue with this bankruptcy. Well, the bankruptcy court will offer now a Chapter 7. That's what they will offer. They'll try to, look at the Chapter 7, look at your finances, all of that. And if it works out, they might offer your client a Chapter 7 and then go through that whole set of plans for a Chapter 7. Okay, so there's 2 things your client can do. They can be honest, tell the bankruptcy court right away. Bankruptcy court will try to work with the creditors, right? Or they can tell the bankruptcy court right away, and the bankruptcy court can offer you a Chapter 7 at this point. So there are options. They're not like just, we're going to dismiss your claim, dismiss your petition, and it's done. Okay, they give you options, but let me tell you something. A lot of clients don't take up the options. People think, I don't know what it is about clients in particular. They think by not mentioning things, by, ignoring things, it's going to get better. Well, no, when it comes to the bankruptcy court, they're pretty strict. It's not like you have a creditor where you're going to be 10 days late, they're going to charge you a late fee. It's not the way it works with the bankruptcy court, right? You have to be upfront. And a lot of people just sleep on it, but they sleep too long. And if you sleep too long, you're going to be back in square one, but a little bit worse, right? So people don't see the big picture. And the big picture is this. Try your best to get these payments in. If you have trouble, let the courts know. They're there to work with you. What they don't know, they can't help you with, right? So we try to get that across to certain clients. And the ultimate decision maker, by the way, everybody, is your client. Yeah, you can't be a babysitter. You can't be a mom and dad. You can't, they have to make, they're grown people. They have to make their own decisions. And you will see this. And it's sad. It really is sad because now they're in your office and there's no helping them. It's done, right? They're in a bigger problem now than they were when they first started. So it is a sad situation, but the only thing you can do is remind your client. You can't force them to do anything, right? Okay. So prior to completion of payments, the plan may be modified at the request of who? Your client. You can't request this. The attorney can't request this. The trustee might request it, or an unsecured creditor. Okay. So if they have an unsecured creditor that's saying, I haven't got my last, I'm waiting for my payment of my 6 month payment and I haven't received anything. And then the unsecured creditor might just jump in there and say, we need to modify this plan. They want to get paid. You tell me which unsecured creditor is worried about your client. This is very uncommon. They're not going to jump in there and save your client. Okay. But if it's a big debt for an unsecured creditor, they want to save your client. No, they want to save themselves. They want that $10,000 paid. If not, they're out $10,000. So they might jump on the bandwagon and say, you know what, we need to modify this plan for this debtor. They might do that depending where they're at in the system. Okay. It may happen. Most likely it's the debtor saying it or the trustee. Okay. So if any interested party objects to the modification, they might object. The court must hold another hearing, to determine approval or disapproval of the modified plan. If somebody says, no way, Jose, it's not going to work for us, right? Then they have to have a hearing. And at that point, the court will decide if we're going to approve the modification, or you know what, we're going to disapprove it, but we're going to offer you a Chapter 7. Okay? We're going to take you out of this Chapter 13.